In 40 years on this bench, I have learned to keep my face neutral. It is not natural. It is a skill built over years, the professional discipline of a person who is supposed to receive the worst of what people do to each other and respond with steadiness rather than reaction. The face of a system that thinks before it speaks. I have maintained that face through testimony about things I would give a great deal to unhear, through arguments so cynical they tested every year of restraint I had built, through moments that required me to breathe and wait and respond rather than react. On the morning of March 19th, I had to work harder than I have in a long time. What walked through those doors was not the most dramatic case I have heard. No weapon was involved. No one was going to prison. The dollar amount, while significant, was not extraordinary by the standards of civil litigation. What made me press my hands flat on the bench and take a slow, deliberate breath before I spoke, was the timing. The specific, calculated, deliberate timing of what had been done to a 64-year-old man named Harold Sutter, who had spent 38 years working for the same company and who had been terminated on the morning of March 1st, the day before his retirement was scheduled to begin. They had waited until one day before. I want to tell you this whole story. I want you to stay with me through all of it, because the part that matters most does not happen in a courtroom. It happens in a hallway. And if you are not with me when we get there, you will miss the only moment in this story that gives me any faith at all, so stay. Harold Sutter had spent 38 years as a maintenance supervisor at Keystone Industrial Manufacturing, a mid-sized facility on the west side of the city that made precision components for the aerospace and automotive industries. He had started there at 26, straight out of a 2-year technical program, hired as a junior technician to help maintain the equipment that kept the production floor running. He had learned fast and worked hard and been promoted to team lead within 4 years and to supervisor within 8. By the end, he was managing 11 technicians, overseeing a maintenance budget that ran into 7 figures annually, and carrying in his head the kind of accumulated knowledge about a facility, which machine had which quirk, which repair lasted and which one didn't, which vendor could be trusted and which one couldn't. That takes decades to build and cannot be replaced by any number of job postings or training programs. He was, in the plainest sense, irreplaceable, and the company had known that for 30 years. He had planned to retire at 64 for as long as he and Catherine had been planning anything together, which was a long time. They had met when Harold was 31, married when he was 33, and had spent the following 30 years building the kind of life that does not photograph well, but feels right from the inside, a house paid off in 2019, 2 children who were grown and doing well, savings that were modest but real, and Harold's pension. The pension was the foundation of everything. It was a defined benefit plan, the old kind, the kind that employers used to offer and largely stopped offering because they cost too much when employees actually collected. Harold had been contributing to it for 38 years, and the company had been matching those contributions, and on the date of Harold's retirement, the full amount would vest and become his to draw on for the rest of his life. The employer's accumulated contribution, at full vesting, was approximately $400,000, plus lifetime supplemental health benefits that the actuarial tables suggested were worth another $100,000 over a standard retirement period. The pension vested on March 2nd. The company terminated Harold Sutter on March 1st. The termination letter was delivered at 8:47 in the morning. Harold had driven to work in the dark, as he had driven to work for 38 years, parked in the spot he had parked in for 15 years, walked through the door he had walked through 10,000 times, and been met by someone from HR and someone from legal and told his employment was over. The stated reason was performance. Equipment logs not completed to standard. Maintenance reports submitted late. A pattern of deficiency that the letter described as having developed over several months and rendered his continued employment untenable. Harold Sutter had never received a written warning, not once, not in 38 years. His most recent performance review, 6 weeks before the termination, had rated him as exceeding expectations in 4 of 5 categories and meeting expectations in the 5th. His team's equipment uptime record for the previous year had been the best in the facility's history. His manager had sent him a personal email in January, which Harold had saved, saying the department was in the best shape it had ever been. There was no performance issue. There had never been a performance issue. What there was a pension worth $500,000 that the company would not have to pay if Harold's employment ended on March 1st instead of March 2nd. Harold Sutter sat at the plaintiff's table in my courtroom, and he looked like a man who had been hit by something he did not see coming and had not yet fully recovered his balance. He was a big man, broad and solid, the kind of physical presence that comes from decades of physical work. But he sat slightly forward, slightly careful, the way people sit when they are in pain they are trying not to show. His wife, Catherine, was in the gallery. She had brought a folder. She had been the one, Harold told me later, who had done most of the research, who had called the labor board, who had found the attorney, who had refused to accept that 38 years could simply be erased 24 hours before the finish line. The attorney she had found was a woman named Grace Nakamura. She was 41, labor litigation, and she had reviewed the case and agreed to take it on contingency, which told me everything I needed to know about how strong she believed the claim was. Across the room, representing the company, Keystone Industrial Manufacturing, was a senior partner from a large firm, a man named Douglas Fairfield, who had been doing corporate defense work for 30 years and who sat with the comfortable confidence of someone who had won more of these cases than he had lost. He had a very thick binder. I called the case. I asked Grace Nakamura to present the claim. She was precise and she was fast. She laid out the timeline in 11 minutes, 38 years of employment, consistent performance reviews, no documented disciplinary history, a pension vesting date of March 2nd, a termination date of March 1st. She submitted Harold's performance reviews going back 5 years. She submitted his most recent review, 6 weeks before termination, exceeding expectations, and she submitted the termination letter. She said, "Your Honor, the timing of this termination is not a coincidence. The company saved itself $400,000 in pension obligations and lifetime benefits by ending Mr. Sutter's employment one day before vesting. The documentation used to justify that termination was manufactured after the fact. We intend to demonstrate that." I looked at Douglas Fairfield. He rose smoothly and began. "The performance issues were documented," he said. "The company had records. The decision had been made through proper HR channels over several weeks. The timing relative to the pension date was," he acknowledged, "unfortunate in appearance, but coincidence and intent were different things, and the company had acted within its legal rights." I said, "Mr. Fairfield, before we proceed, you said the performance issues were documented. I would like to see when those documents were created." He said, "The records are in our submission, Your Honor." I said, "I have reviewed your submission. The documents you submitted as performance records, the equipment logs, the maintenance reports, I would like to see the metadata, the creation dates on those files." There was a pause. Not a long pause, but the kind of pause that has a quality to it. The kind that tells you something is happening on the other side of the room that the other side was not prepared for. Fairfield said, "Your Honor, that level of technical detail was not anticipated in the submission." I said, "Then we will need to get it. I am not prepared to accept performance documentation as genuine without being able to verify when it was created. In a case where the termination occurred one day before a pension vesting date, the creation dates of the performance documents are not a technical detail. They are central." I called a recess. Now, before I tell you what happened during that recess, I need you to do something. If you have made it this far in this story, you already understand what was done to Harold Sutter. You understand the math of it. One day, a pension worth $500,000, documents created in 48 hours. I need you to hit that like button right now, not at the end right now, because what is about to happen in this courthouse hallway is something I have never seen in 40 years on this bench, and it deserves to be seen by as many people as possible. Go ahead. I'll wait. What happened during that recess is the reason I am telling this story. Douglas Fairfield's associate, a younger attorney named Philip Garrett, who had been sitting beside him and who had throughout the morning been noticeably quieter than associates usually are in hearings of this kind, Philip Garrett asked to speak with Grace Nakamura in the hallway. I learned what was said in that hallway from both attorneys, who each described it consistently, which is the only reason I am confident in telling you. Philip Garrett told Grace Nakamura that he had joined Keystone's legal representation 3 weeks earlier, brought in after the original filing when the case was already assembled, that when he had reviewed the case materials, doing what junior attorneys do, reading everything before he could be useful, he had noticed something. The timestamps on the performance documentation did not align with what they purported to document. Logs from July had creation dates in February. Reports covering a 6-month period had been created in a 2-day window. He had flagged this to a senior colleague and been told it was a file management issue and not his concern. He had spent 2 weeks sitting with that answer. He was 29 years old. He had 2 years at this firm, a student loan balance that would take a decade to clear, and a career that had barely started. He understood exactly what he was about to do and what it would cost him, and he stood in that hallway and did it anyway. He gave Grace Nakamura a USB drive. Are you still with me? Because I need you to hear what was on that drive. On that drive was his own analysis of the document metadata, the actual creation dates of every performance record Keystone had submitted. The earliest of those records had been created on February 27th, 3 days before Harold's termination. The logs and reports that allegedly documented months of performance deficiency had been written in a 48-hour window at the end of February. Grace Nakamura came back into my courtroom and handed me the drive. I looked at Douglas Fairfield. He did not yet know what his associate had done. I said, "Mr. Fairfield, I have received additional materials that I would like to address. I am going to ask you about the creation dates on your performance documentation. What followed was 11 minutes that I will not forget." Fairfield examined what I had been given. He spoke quietly with his associate. He looked at me. He looked at Harold Sutter. He looked at Catherine in the gallery, who was sitting very still with her folder in her lap and her eyes on the front of the room. Then Douglas Fairfield, 30 years of corporate defense, stood up and said, "Your Honor, I need to request a brief suspension of these proceedings to confer with my client." I said, "You may have 20 minutes. He took 19. When he came back, he said, "Your Honor, Keystone Industrial Manufacturing will be withdrawing its defense of this claim and will be prepared to discuss resolution terms." The gallery made a sound, not loud, just the collective exhale of people who had been holding something and were releasing it. Harold Sutter sat very still. I looked at him. His jaw was set. His hands were flat on the table. He was not celebrating. He did not look like a man who had won something. He looked like a man who had been told the thing he already knew was true was actually true, and that is a different thing from winning. That is a different feeling entirely. I addressed the courtroom before calling the recess for settlement discussions. I said, "I want to say something for the record before we proceed." I said, "Harold Sutter worked for one company for 38 years. 38 years. He showed up. He did his job. He built something, not wealth, not fame, something harder to build and harder to replace. Knowledge, trust, institutional memory, a team that functioned because he knew how to run it. He did this from age 26 to age 64, and he asked for one thing in return, that the pension he had earned, the retirement he had planned for, the finish line he had been walking toward for nearly 4 decades would be there when he arrived." I said what this company did was wait until he was 24 hours from that finish line and then remove it, not for cause, not because Harold Sutter had failed at his job. The documents that were supposed to justify that decision were created in a 48-hour window. Someone sat down and wrote a false record of performance deficiency for a man who had been rated as exceeding expectations 6 weeks earlier because $400,000 was worth more to the company than 38 years of Harold Sutter's life. I said, "I want Keystone Industrial Manufacturing to understand something clearly. This courtroom has seen the metadata. This courtroom knows when those documents were created, not when they were dated, when they were actually created. A man who spent 38 years doing his job correctly was handed a termination letter citing 6 months of documented performance failures that did not exist 48 hours before those documents were written. That is not a paperwork problem. That is not a coincidence. And when this case resolves, however it resolves, that finding is part of the permanent record of this proceeding and will remain part of it." I looked at the space where Fairfield had been sitting. He had left the room to call his client. I said, "There is one more person I want to acknowledge." Philip Garrett, who is also no longer in this room, made a decision this morning that had nothing to do with career advancement and everything to do with conscience. He sat with a difficult thing for 2 weeks, and then he walked into a hallway and did the right thing. That is not a small act. In a profession that does not always reward it, that is an act of genuine courage. I struck the gavel and called the settlement recess. The settlement was reached before end of business that day. Both sides returned to the courtroom to confirm it on the record. I was told the terms, Not all of them. Those remain confidential, but the structure. Harold's pension, fully vested, retroactive to March 2nd as though the termination had never occurred. Back compensation, covering the period from March 1st to settlement. The lifetime supplemental health benefits restored in full. And a separate amount, the amount Grace Nakamura had described as appropriate given the circumstances and the evidence, that I understood to reflect the company's awareness of what the metadata evidence would have done to them in front of a jury. Harold Sutter stood when the settlement was confirmed on the record. He shook Grace Nakamura's hand. He looked at me and he nodded, just once, the way a person nods when words seem insufficient, and they do not want to use insufficient words. Then he walked out of my courtroom to where Catherine was waiting in the hallway. I was told she had been sitting there the whole time, folder still in her lap, not checking her phone, just waiting. When Harold came through the door, she stood up and they held each other for a long time in the courthouse hallway while other people walked past them on the way to other cases. I did not see this. My clerk told me about it later. She had walked past them on her way back from the copy room and had taken the long way back. Catherine Sutter sent my clerk a note 3 days later. I have kept it. It is short. It says he went home and sat in the yard for a long time. He said he just needed to sit outside. I think he was all right. I have thought about that image more than I can count. A man who worked with his hands for 38 years, who drove to work in the dark and managed 11 people and kept the machines running and did all of it correctly for so long that the company had stopped noticing, sitting in his yard after the thing that was done to him was finally undone, not celebrating, not on the phone, not talking to anyone, just sitting. There is something in that image that I believe is true about a certain kind of person, the kind that keeps going when keeping going is the only option, that does not complain about the difficulty because complaining changes nothing, that builds a life through sustained daily effort, and asks only that the promises made to them are kept. Harold Sutter had been that person for 64 years, and when the promise was finally after everything kept, he went home and sat in his yard. That is what justice looked like on March 19th, not a courtroom moment, a man in a yard. I have also thought about Philip Garrett. I was told by Grace Nakamura that he left that firm within the month. He did not tell her where he was going. He said only that he needed to find a different kind of work. He was 29 years old. He had student loans and 2 years at a firm and a career that he redirected or ended, depending on how you look at it, because he could not sleep with what he knew. He had sat with it for 2 weeks. He had gone to work every day and looked at the file and known what was in it and known what was being done with it, and eventually he had walked into a courthouse hallway and made a different choice. I do not know what that cost him in concrete terms. I know what it gave Harold Sutter. That is the whole of March 19th, a man who worked 38 years, a company that waited until the last day, documents written in 48 hours, a young attorney who could not sleep. I have been on this bench for 40 years. I have seen a great deal of what money does to people when they have it and the person across from them does not. I have seen how power operates when it believes no one is watching and no one will push back. I have seen it go wrong far more often than anyone in any position of authority should be comfortable admitting. March 19th went right, not automatically, not because the system caught what happened. The system was being used to hide what happened. It went right because Catherine Sutter made phone calls, because Grace Nakamura asked the right question about metadata, because Philip Garrett could not sleep 2 weeks in a row. Justice on March 19th was not a machine operating correctly. It was 3 people, none of whom were supposed to be the hero of this story, refusing to let it fail. Now, I need something from you before you leave. If this story made you angry, if you sat there and thought about someone in your own life who gave decades to a company and was discarded when honoring that became inconvenient, I need you to share this video right now, not in an hour, right now. Copy the link and send it to one person, just one, a coworker, a parent, a friend who is close to retirement and trusts their employer more than they probably should. Because Harold Sutter had Catherine. Most people do not. Most people get the termination letter and go home alone and believe there is nothing they can do. There is something they can do. They can call a lawyer. They can ask for the metadata. They can have someone like Philip Garrett in a hallway on the right day, and the only way that happens is if people understand that it is possible. So share it right now and subscribe to this channel before you close this page. Not as a favor to me, because I have 40 years of mornings like March 19th, and I am going to keep telling them every week. Another person who sat across from power and needed the room to work correctly. I am going to be here. Leave me a comment. I want to hear from you specifically. Tell me about someone you know who gave years to a job and was treated as disposable. Tell me what happened. Tell me their name if you want to. I read every comment, every single one. Harold Sutter is in his yard right now, or he is wherever people go when the thing that was taken from them is finally returned. I do not know what that feels like. I imagine it feels like sitting in a chair in the sun and not having anywhere you need to be. He earned 38 years. He earned every minute of it.